Welcome to Legal Lines. This program is brought to you by the York County Bar Foundation. My name is Tom O'Shea. I'm the host of the show, and today my guest is attorney Daniel Fennick. Dan is an attorney with the law firm of Anderson, Converse and Fennick, and the topic is public school law, or education law, if you will. So welcome, Dan.
Thank you.
And like I said, you handle education law cases. Could you explain to the audience what exactly that entails?
Sure. I've been doing this since about 1983, and generally takes the form of families coming to me because their children are having some kind of issue with the public school district. It could be that they're being subjected to some kind of discipline, or the child isn't succeeding, or child has some kind of educational handicap which isn't being handled according to the parents the way the school district is required to handle it.
So you typically would be representing the child or the parents in that type of a case?
Well, hopefully they're on the same page, but typically, I mean, I consider my client to be the child. Okay. I also represent some charter schools, so I've seen education law from the standpoint of the school as well.
And from the school's point of view as well as the students' or family's point of view?
Right.
Okay. Let's start out with something very basic, and it's a question that comes up from time to time. In Pennsylvania, the public school system is broken down into school districts.
Right.
Do parents have the right to send their child to any school district they desire, or is it based upon where they live?
Yeah, the school district that you attend is based on where you live, and so that, for example, there are parents who live in the city of York who, whether rightly or wrongly, feel that that's not the right district for their child, and so they might want their child to attend suburban, which is the district that borders York City. They don't have a right to do that. And there are some districts who are very, very aggressive about policing that and making sure that the people who attend the school actually live within the school district limits.
Well, every once in a while I hear of people who have like a relative who lives in a different school district, and they say the child lives with the relative so the child can attend the school. Is that type of stuff permissible?
It's not technically permissible. The law on this is very outdated, but what the school code says is that if you aren't living with your parents, you can be registered in the school district where you're living if the people you're living with have guardianship over you, if they agree that the parents aren't going to support you, and if you don't go back and live with the parents over the summer. So, for example, if, I've had situations with a child who isn't doing well in a school district for one reason or another, and the parents say, you know what, my son could go live with my brother who lives in Dallastown as opposed to Red Lion where the child isn't doing well. And Dallastown, if they want, can insist that the uncle meet all these requirements, which would mean they have to get legal guardianship, which is a complicated thing to get. And if the child goes back to mom and dad's over the summer, the child does not qualify to live in Dallastown. And if the parents say to the uncle, well, look, you're supporting our child, he's living with you, we want to give you some money to help out, that again would disqualify the student from attending Dallastown. Now, some school districts are much more lenient and will agree to not follow those requirements. And my position has always been, for example, between Dallastown and Red Lion, yeah, there are probably some kids attending Dallastown who should be going to Red Lion, and there are probably just as many kids attending Red Lion who should be going to Dallastown, so it all balances out. But there are districts who don't feel that way.
The other area where this comes up, I believe, is where you have separated parents.
Right.
Mom lives in one school district, dad lives in another school district. And is there a rule with respect to where the child must attend?
The rules, again, aren't very clear. But if a parent doesn't have 50% custody at least, the school district can legitimately say this child doesn't live in this district and can't.
So let's say, for example, dad lives in a school district, he has a house, he pays real estate taxes, school taxes, and mom lives in another district where she pays real estate taxes, school taxes, but the child lives more with mom than with dad. Could the dad say, well, could both parents say, we'd rather the child go to dad's school district, even though the child lives more with mom?
If the school district is paying attention and doesn't want the child, talking about dad's school district, I think dad's school district could legitimately say this child isn't enough of a resident of this district.
Okay. And I suppose in custody situations where it's equal between mom and dad, then either school district would be required to take the child.
Right. And if the parents agree, the child's going to get registered in one school district, then it's not really going to be an issue.
Okay. All right. Well, the next topic I'd like to go over is school discipline. Like, when does a school have the right to discipline a child? That would be the main focus.
Okay.
I think we can all agree that if a child misbehaves in school, the school has some right to discipline a child. Is there a limit to that right, and do the parents have any say in what type of discipline a school may use?
Okay. There is a limit as to what school districts can do as far as discipline. What the law says is that schools have the right to have influence or control the behavior of a child when that child is in the charge of the school district. So, for example, and I've had this happen, there's a district that has felt for years that it can control the behavior of kids when the kids aren't under the supervision of the school. And I've had a family who came to me because there was a situation where their teenage child was accused of drinking at the York Fair on a Saturday, and the school district decided that they were going to investigate that, and the school has absolutely no right to investigate that because the child is not subject to the supervision of the school on Saturday at the York Fair.
Now, I want to take that scenario you give. Child's at the York Fair on a Saturday night, has nothing to do with school. It's not a school-related activity. He is doing something inappropriate. He's underage drinking is the example you used. What if the child was on a sports team, the football team, for example, and in the fall during York Fair time, and he signed a contract with the school that said he would not take any type of alcohol while he's on the football team?
Right. That changes the situation, and the reason that it changes it is because the parents and the student generally have agreed. They've voluntarily given this supervision right to the school district, and they do that as a condition of the student being on the football team or being in the drama club or whatever. And if that happens, the school cannot kick the student out of school for drinking at the York Fair. But if the student has said, while I'm on the football team, I promise I'm not going to drink, and if I drink, I can be kicked off the football team, then the school district will do that. School districts have even taken that to the extremes of if a student is at a party where alcohol is being served, even if the student doesn't drink, school districts have taken the position that, well, they signed an agreement saying they wouldn't be around any alcohol, so we're going to kick them off the football team.
So really this is based upon an agreement that the child has with the school district.
Right.
And the only penalty that the school can impose in that type of situation is to take them out of that activity?
Right. Because
they could, for example, if we use the same scenario, a child is at the York Fair and he's consuming alcohol, which I believe alcohol is not allowed at the York Fair anyway, but let's say that he is consuming alcohol and the school found out about it. He was on a sport team and he signed a contract. Could the school say, because of this, we are going to give you detention? Because of this, we're going to not let you take advanced classes, or is the punishment solely you cannot be on the football team?
The punishment is the football team, and the reason is that students do not have a right to participate in sports or extracurricular activities. They do have a right to go to school. So it's much more difficult for a school district to take away a right than it is to take away the privilege of participating in an athletic team or extracurricular activity.
Okay. Now, there'd be a completely different scenario if the child was doing this on, let's say, a field trip that was sponsored by the school.
Right.
If let's say there was an overnight field trip to some historic park or whatever, and the children were participating in a drinking party in their hotel room, but it was a school function.
Right. That's the school-sponsored event, and then the student is under the supervision of the school district, so the school district does have the right to impose discipline, just as they could at a school dance or at a basketball game and
Or sitting in algebra
gym.
class.
Right.
There would be no distinction between what the child would do in algebra class or what the child would do at school dance, for example.
Right.
It would be a school function, et cetera. And would the same apply to a school bus in order for a child to get back and forth to school?
Yes. I mean, generally the rule is that the student is under the school supervision from the moment she leaves the house in the morning until she gets back to the house in the afternoon.
Okay. And what are there limits to what type of discipline is appropriate for certain type of behavior?
Yes. The way it works is that the law requires that the school district, it's referred to as defining and publishing what kind of offenses can lead to a student getting kicked out of school. Now, in my world, when I have to work within the court system. The line is sort of 10 days. A school district can suspend a child for up to 10 days, and there really isn't a whole lot of recourse. There are some, excuse me, there are some rights in the law about that you have a right to a meeting with the principal to talk about the reasons for the suspension. But if the principal doesn't want to change his or her mind, the suspension is going to be in effect. Once you hit the 11th day, then things change, because the law says that if you're out of school for more than 10 days, it's actually considered an expulsion. An expulsion is any exclusion from school for a period of more than 10 days.
So it's a suspension until 10 days?
Right.
Expulsion after 10 days?
Right. And if you're going to expel a student, then the student has more rights. The student has a right to a hearing before the school board, has a right to a lawyer, has some rights to cross-examine witnesses. I still wouldn't consider a particularly fair proceeding.
All right. Well, now you're talking about a pretty drastic discipline where you're talking about suspension or expulsion.
Right.
I mean, there's other types of behavior. Let's say we're dealing with a second grader who talks during class. It seems to me that there would be a limit to how he can be punished. They couldn't discipline him by an expulsion, for example.
The schools are supposed to write rules that say what types of offenses lead to what types of punishments. What school districts have been doing lately is they've been publishing a list that says, for example, talking out in class is a level 1 offense, for example, and it leads to detention or whatever, but then they'll say for repeated level 1 offenses, you move up to more significant discipline. They'll also put a catch-all in there that says that, well, yeah, normally if you talk in class, that's a level 1 offense, but we reserve the right to kick you out for anything that we want. And unfortunately, the courts have been pretty lenient with school districts in allowing that kind of guideline.
Okay, so is each school district required to have such a list of offenses and what the punishment would be?
Yes, they're required to publish the list, and most school districts will put the list in the school calendar that everybody hangs up on their refrigerator, or they'll put it in some kind of handbook, and they'll have the parents sign a receipt at the beginning of the year to establish that the parents have received the handbook and read it.
We're just out of time on our first segment. This is Legal Lines. My guest is Dan Fennick. Welcome back to Legal Lines. Our topic today is school law or education law, and my guest is attorney Daniel Fennick with the law firm of Anderson, Converse and Fennick, and he handles many school law cases. And Dan, right before the break, we were talking about discipline, and you defined expulsion from school as any suspension of a student for more than 10 days.
That's right.
So 11 or more days, if a child is told that they cannot come to school because of their behavior, that's considered an expulsion.
Right.
Now, if the child or the child's parents wish to challenge the school's right to expel a child, what is the process?
The school district who wants to expel a child, and I should clarify that by saying it's the administration who wants to expel a child, has to send notices to the parents saying, this is what your child is accused of doing. And if the parents want to challenge that, it's basically a trial in front of the school board. It generally takes place in the evening because that's when school board members are available. And the administration has to prove, number one, that the student did the offense that he's charged with committing. And number two, if the administration proves that to the satisfaction of the board, then they have to prove that an expulsion is warranted. So generally, what happens is there'll be a hearing. The students get a notice that says they're entitled to a lawyer, they're entitled to bring witnesses in, they're entitled to see the statements of witnesses against them. And there's a little trial where the administration, vice principal, principal, whatever, will put witnesses on to say, this is what this student did, this is how we're going to prove it. The student's lawyer can cross-examine those witnesses, and then the student has a right to put on his or her own testimony. At the end of that, then the school board will decide, is the student guilty or not guilty? And if guilty, then the proceeding goes on a little bit further, where they'll talk about how long should the student be expelled. And they'll look at things like prior offenses and what kind of grades does the student get and how supportive is the family and that kind of thing.
So technically there are two issues. One is whether or not the school district should expel the child, and number two, how severe should the expulsion be?
Right, and the first issue is more guilty or not guilty. Now, it's not like a criminal trial. Student doesn't have this presumption of innocence that the administration has to prove guilt beyond a reasonable doubt, but they do have to prove that the student did the offense that they're charged with.
Now, let's say this happens and the child is expelled and the expulsion is for a significant period of time. Aren't there laws that require that children go to school?
Yes.
So what do we have now, a truant or?
No, the school district is actually required to provide an education even for students that are expelled until the student is over 16. So what a lot of the school districts in York County have is they have an alternative school, which is often off campus. There's a number of them around who have contracts with the school districts that say, we will take your expelled students. Another thing that happens is the student is entitled to be educated 5 hours a week. So sometimes the school district will say, well, you can come into the school after everybody else is gone. So you can come into the school at 4 p.m. every day, and you'll work with a teacher for an hour who will tutor you. And that's how the students get their 5 hours in.
Okay. Now, let's say there is an expulsion, and it goes before the school board, and the student loses. The school board basically affirms what the administration of the school did. Is there a way to appeal that?
You can appeal that to the local court, where a judge will look at the record of what happened at the expulsion hearing and decide whether what the school board did is correct. However, it's not the judge's position to decide, well, the school board gave an expulsion of a month and we think it should only be 20 days. The judges are required to generally to defer to the discretion of the school board unless the school board makes a very significant error. I kind of use the analogy of it's like challenging an umpire's call in a baseball game. If the umpire says safe and you think that the runner was out, you're not going to get anybody to overrule that call. But if the umpire makes a mistake about the rules of baseball, then the commissioner might step in and say, well, the umpire made a mistake about the rules, therefore we're going to have to replay an inning or do something like that. So we're looking in an appeal to see if the school board made some kind of legal mistake.
And how long does it typically take from the school board decision to a court hearing in front of a judge?
Well, it can take months. I mean, you don't typically have a hearing in front of a judge. There's a transcription made of the hearing in front of the school board, and the judge reviews that record. And the case...
Oh, so there's not an actual hearing with all the witnesses again. It's basically review whatever record was made before the school board.
Right. If the school board has made a record. Now, I've had cases where the school board thought they were making a record and the tape didn't work. So we had to have a hearing all over again in front of a judge.
Well, absent a mistake like that, what the important lesson would be here is to take that hearing before the school board extremely serious, because it's not just a matter of, well, let's see what happens there and then get the attorney to take it to court. because if you're talking about cross-examining witnesses and going over evidence, it's best to have the best representation at that school board meeting.
That's exactly right. And
Okay.
the other thing is that if the school board makes a mistake, for example, let's say a legal mistake is made that something that a student is expelled for having what's considered a weapon, and under the law, it's not really a weapon, for example. In order to have a successful appeal, you have to make an objection at the right time at the school board hearing. And if you don't do that, the judge isn't going to reverse the school district's decision. So if you don't have a lawyer at the hearing, parents aren't going to know when to make the objections, and then when you want to appeal, there's really nothing to appeal. And I've had a lot of situations where the parents come in and it's too late, and the parents will say, but the principal said I didn't need a lawyer and everything would be fine. And you can't always take that seriously.
Well, we're both lawyers, and I think people might think we're trying to get more work here, but it is important that you have the proper legal representation when you go to that school board meeting.
Yes.
Okay.
I mean, I've got plenty of work.
Okay. All
so
right.
if people are going to fight it, they need to fight it from the beginning.
And because that's where the record is going to be made.
Right.
Okay. I do want to flip to another subject right now, and that is students with disabilities. How must the school accommodate students with disabilities?
There are two laws that cover students with disabilities. They're both laws passed by Congress back in the 70s. One's called the Individuals with Disabilities Education Act, and the other one's called the Rehabilitation Act of 1974. And both of those laws say that we have an obligation as a society to educate everybody, not just the kids who can learn the way we would like everybody to learn. There are, and a lot of those disabilities people wouldn't argue with. For example, student has a hearing deficit. Most people would say, well, of course we should give them the same education we're giving everybody else, so the school should be required to install some kind of special audio system so that a student with a hearing deficit can learn. There are some disabilities that people aren't as sympathetic to. For example, emotional disabilities that prevent students from learning correctly. Those are also students who have a right to an education, and schools are required by federal law to adapt the program for those students so that those students can be successful.
Well, I believe some of the common issues that come up in today's society are ADD, ADHD, compulsive disorders. I mean, those are types of problems that I hear many children have, and the school has to do something to accommodate those children.
That's right. I mean, these are real disabilities. I mean, attention deficit now is finally the science is catching up with what a lot of people have known, and you can see on brain scans that people with attention deficit, their brains work a little differently, and they do not have the same ability to learn the way that the, quote, normal kids
So
learn.
what must the school do to accommodate a child with attention deficit disorder?
Well, it depends on what the child's specific weaknesses are. I mean, the easy accommodations would be putting a child in the front of the room, helping a child get organized. I mean, these kids generally are not capable of remembering things the way most people would remember them, and it's referred to as an executive function disorder. You could say to a kid who is, as I said, I'm using the word normal, you know, I want you to do these 5 things for homework tonight. Oh, and before you start, you need to take out the garbage and you need to do this or that. Students that have attention problems just cannot remember to do that. And so there are systems that you can use to help those kids learn. And districts are supposed to teach the children those kinds of systems. Teach them how do you set things up for yourself so that you will remember. And the kids can't write the assignments down in their notebooks or whatever. The school district should come up with a way to help the kids write that down.
There's a term that I hear many people use with children in school that's called I believe it's an IEP.
That's correct.
And what is an IEP?
An IEP stands for Individualized Educational Program, and that's a document that's required by one of those federal laws that if a student qualifies for special education, which doesn't mean being put in a special education classroom, it's much broader than that. But if a student qualifies for services, then the parents, the school, and some professionals, a school psychologist or whatever, are supposed to sit down and craft this document so that the school modifies what it's doing with this student to meet the student's unique needs, that's the phrase under federal law, so that the student can be successful.
Okay, so now we're talking about special needs of children with some, let's say, learning disabilities. Are there also accommodations that would need to be made for physical disabilities?
Yes.
I think you used the hearing.
Right, and the hearing impairment, there's also visual impairments. The law that says that students have to be accommodated for the disabilities, it's the same law that has resulted in curb cuts in sidewalks so that people in wheelchairs can get into a school building. And there's always ramps now into school buildings, and there's elevators for kids in wheelchairs or kids who can't handle stairs. It's all the same law.
Now, we also hear of children that are sometimes referred to as gifted children, where maybe the classroom work is at a slower pace than they need to go. Are there special programs that exist for gifted children?
There are, and the federal laws that I refer to do not cover gifted children, but there are state laws that cover gifted children, and the schools are supposed to design a program for gifted kids that allow those kids to flourish, and that's a tough thing to do because you don't want to punish a gifted child for being gifted. So you don't want to say, you know, Mary, you're a really smart kid, so you're going to do twice as much homework as everybody else. That's a really tough line for districts to walk.
But is it pretty much the same laws that govern that as would govern a child with special needs because of being slower instead of being gifted?
Well, the gifted child doesn't have quite as many rights, but there is something called a gifted IEP. It's referred to as a GIEP.
And I'm going to have to cut you off right there because we're almost out of time.
Okay.
This was Legal Lines. My guest was Daniel Fennick. The topic was school law. Thank you for joining Legal Lines. It's brought to you by the York County Bar Foundation.